Chief Justice John Roberts is leading the charge to uphold state bans on transgender healthcare. His remarks during a Supreme Court session last Wednesday suggested that a majority of justices might support such bans, a stance reminiscent of his dissent nearly a decade ago when the court recognized a constitutional right to same-sex marriage. In 2015, Roberts famously asked, "Who do we think we are?" as he opposed judicial intervention aimed at protecting individual rights. Now, as he leads the court, Roberts appears positioned to guide the decision in a crucial case concerning transgender rights. Despite significant differences between the cases, especially with the current one focusing on children, both the 2015 same-sex marriage case, Obergefell v. Hodges, and the ongoing transgender rights case, U.S. v. Skrmetti, share a common theme. Challengers argue that the legislative process has failed them and urge the court to defend their constitutional rights. Roberts dismissed the claim that Tennessee's ban on gender-affirming care amounts to sex discrimination, asserting that medical decisions should be left to state legislatures. He emphasized that the Constitution entrusts such decisions to elected representatives, not to unelected judges, none of whom are medical experts. In his earlier dissent on same-sex marriage, Roberts criticized the majority for what he saw as the hijacking of the democratic process. 5 lawyers have ended the debate and imposed their own vision of marriage, he wrote, adding that removing such a significant issue from the people would make societal acceptance of same-sex marriage more difficult. This marked the only time Roberts read parts of his dissent aloud from the bench, an unusual move meant to signal his strong objection. The court's ideological shift since 2015 was evident in the arguments over transgender rights. At the heart of the case is whether laws affecting transgender individuals deserve heightened scrutiny under the Constitution's Equal Protection Clause. In the past 3 years, about 25 states have passed anti-trans laws, and President-elect Donald Trump made transgender rights a key issue during his campaign. Meanwhile, same-sex marriage has become less prominent in political debates since Obergefell. In the courtroom, conservative justices swiftly aligned behind a position advocating minimal judicial scrutiny for such laws. In contrast, liberal justices, including Justice Sonia Sotomayor, voiced frustration. Sotomayor pointed out the harm transgender youth could face by being denied puberty blockers and hormone treatments, highlighting the mental health risks, including drug addiction and suicide attempts, associated with gender dysphoria. However, these arguments garnered little support, with Roberts continuing to dominate the conversation about the court's role in such cases. Justice Brett Kavanaugh echoed Roberts' concerns about who should decide, questioning why it wouldn't be better to leave such issues to the democratic process, given the strong scientific arguments on both sides. U.S. Solicitor General Elizabeth Prelogar responded by emphasizing that the Constitution guarantees equal protection under the law, and Tennessee's law denies access to medical treatments based on sex. The law prohibits puberty blockers and hormones for gender transitions, but allows them for other medical purposes, like treating precocious puberty. Kavanaugh raised concerns about potential harm to minors, citing risks such as lost fertility and the psychological effects of detransitioning. Prelogar countered that these concerns could be addressed in the legal proceedings, with states needing to demonstrate a compelling interest in enacting sex-based regulations. Other conservative justices, including Clarence Thomas, Samuel Alito, and Amy Coney Barrett, expressed varying levels of skepticism toward the challengers' arguments, while Justice Neil Gorsuch remained silent. Prelogar assured Roberts that states would still have the authority to regulate medical treatments, but cautioned that it would be extraordinary for the court to exclude traditional standards for evaluating sex-based classifications just because the case involves medical regulation. Roberts appeared to be weighing a middle ground, suggesting that the case might not only be about medical regulation, but also about evolving standards and the technical complexities of treatment. Meanwhile, Justice Elena Kagan sharply challenged Tennessee Solicitor General J. Matthew Rice's argument that the state's ban was based on medical concerns rather than sex-based classifications. She argued that the entire regulation was intrinsically tied to sex, as it targets individuals based on their gender identity. Kagan concluded that it was misleading to claim the law was solely about medical purposes, when those purposes are entirely rooted in sex.